ahead.
Chair Luke, Chair Rhodes, members, I'm Bill Hoshijo, the Executive Director of the Hawaii Civil Rights Commission. The Hawaii Civil Rights Commission strongly supports the proposed marriage equality legislation offered in this bill. Opponents of marriage equality have raised concerns that if marriage equality is recognized, it will require enactment of broad statutory religious exemptions from our civil rights laws, which prohibit discrimination. The HCRC also supports a statutory exemption for clergy who refuse to solemnize any marriage, as well as inclusion of a religious exemption for religious facilities that are used for religious activities, if those religious facilities are not public accommodations. The HCRC opposes any exemption that diminishes protections against discrimination under our public accommodations law. Enactment of marriage equality legislation should not be the vehicle or excuse to weaken or diminish existing civil rights protections. It should be noted that religious exemptions sought by opponents of marriage legislation are not required by constitutional free exercise of religion. Laws of general applicability that do not target religion, like civil rights, employment, criminal, and tax laws, do not violate free exercise. If the legislature decides to incorporate a religious exemption for religious facilities, the HCRC offers suggested language on page 9 of our testimony, which clarifies the scope of the exemption and eliminates the confusing introduction of not for a profit as a qualifying criteria for the exemption, focusing instead on whether there is religious activity involved, or the activity is one whose primary purpose is producing income, the same criteria used in the tax code. We understand that the House is considering exemption language similar to that enacted in Connecticut, which implicitly and arguably creates an exemption that goes further than exempting...
Mr. Hoshijo, you're done. Thank you.
Thank you.
Okay, any questions for the Hawaii Civil Rights Commission? Representative McDermott.
Thank you, Madam Chair. I hope the battery in my mic doesn't die by the end of the day. Thank you, Mr. Hoshijo. Thank you so much for coming this morning. Mr. Hoshijo, you are the civil rights czar. I mean, that's what you do. Take care of everyone's rights, and we appreciate your service, although sometimes we, of course, have disagreements. But if you were here earlier, the question I asked about the school books. Again, my question to you is this. If a Dick and Jane book is in the school, they're called something different now, but they show moms and dads, Spot the dog, et cetera, et cetera. If homosexual couples are not represented across the spectrum in those books, to mean that we don't go in and to replace those books, aren't we creating an environment where those people feel like second-class citizens? And don't we have to redress that as a matter of course?
I think Representative McDermott...
I can't hear you. Could you speak in the microphone?
I think this is really a two-part answer. The first is that the Hawaii Civil Rights Commission has jurisdiction, enforcement jurisdiction, over our civil rights laws that prohibit discrimination in employment, housing, public accommodations, and state-funded services. We don't exercise under our public accommodations law jurisdiction over private or public educational institutions. And there are a number of reasons for that. So we don't get involved in issues of curriculum, admissions, discipline, grading, extracurricular activities. Of course, we do have jurisdiction over those educational institutions to the extent that they are employers, that they operate places of public accommodation. It could be a carnival or a theater, a sporting event where they're inviting the public in, providing goods, services, facilities to the public. But the commission and actually the courts have been reluctant to inject themselves into academic areas because of academic freedom. So as far as, and so this is part of the second part of my two-part answer. I think with regard to curriculum, that in the view of the commission, and given that we don't exercise jurisdiction over that over the development of curriculum, that it's really best left to educators.
Sir, I understand. I'm not talking about curriculum. What I'm talking about is the portrayal in the book of a mom and dad, see Spot run, see Dick run. Here's a mom and dad. In your heart, sir, and you and I are being honest right now as the day is long, if we don't show homosexual couples in an equal light across the spectrum in these books, as an example, getting out of the car, taking the kids shopping, whatever it is that the stories tell in those books, the very lack of that, aren't we creating an environment, once this law is passed, that they are second-class citizens if we don't address that? And that is why I think the people should vote on a constitutional amendment, because they own it.
If you can answer.
Yeah, that's an interesting question, but you know I do think that there are important issues in terms of how minorities are treated in the educational system with regard to texts and all of that. But I don't know that that's impacted by this bill, or and I don't think it changes because of the passage of this bill.
Thank you, sir.
Okay, Representative Lee, followed by Representative Bellotti.
Thank you very much. I had posed a question to the Attorney General, and I just wanted to follow up on it. In the event that we're looking at the public accommodations law, currently the Attorney General indicates it prohibits discrimination on the basis of race, sex, sexual orientation. So my question to him was, from a business owner's perspective, what changes should we pass this law if already they cannot discriminate on the basis of sexual orientation?
The current law already prohibits discrimination in places of public accommodation based on sexual orientation, in addition to all of those other protected bases. So with regard to the law that we enforce, it would not change it. The only thing that could affect it is if the legislature decides to incorporate a broad exemption to our law.
But in the current draft of SB 1, you're saying nothing would change?
With the current draft of SB 1, I think it does create an exemption to our public accommodations law for solemnizations, and I think there are some areas that are problematic, and we have suggested language to clarify or more clearly define the scope of the exemption that's being created.
But as far as for-profit businesses go, like a florist or accessory businesses to that sort of wedding.
Well, I think there is a distinction between the religious exemption that is being proposed in SB 1 and some of the others that are being discussed, like a Connecticut model, and what's been suggested as a conscience provision or an exemption that would extend to individuals based on their sincerely held religious belief or religious belief. And that would really open the door. If you talk about the baker, the florist, any person who provides public accommodations, it would open the door to discrimination, and if it were rationalized, justified by proffered religious reason. And it's important to remember that historically, discrimination, segregation, Jim Crow had a basis in religious belief, and you really don't want to go down that road where you're carving out broad exemptions from this law of general applicability based on individual beliefs to allow discrimination. The other side of that is it would involve the state and entangle us in religion, I think in an impermissible way, because we'd be trying to decide what is a sincerely held religious belief, what's based on a religious belief. That's why we really want to, I guess, warn against erosion of the clear lines and our protections against discrimination in public accommodations.
Thank you very much. Thank you, Chair.
Okay, Representative Bellotti.
Thank you. Two-part question. Can you finish your comment upon the Connecticut language that you were cut off, that the time cut you off on? And then second, and it's a simple yes or no question, no matter what position you take now as the Hawaii Civil Rights Commission to any exemptions that we may be looking at, if a law is enacted, isn't it correct to say that you will diligently enforce the laws that we enact if there's an exemption in it? Thank you.
I'll answer the second question first, and it's an unqualified yes. The legislature makes the law. We enforce the law. The last part of my comments is basically we understand that the House is considering exemption language similar to that enacted.
Okay,
in Connecticut.
what I'm gonna say is we shouldn't use a questioning process to allow testifiers to continue to testify. So sorry, Representative Bellotti.
I apologize. I'll take a look at the written testimony. Thank you.
Okay, Representative Ward.
Thank you, Chair. Thank you, Mr. Hoshijo. Could you give me your opinion of the Connecticut law in comparison to ours?
The Connecticut law implicitly and arguably creates an exemption that goes further than exempting the use of a church facility for a wedding or reception. So we urge caution going down that road. And the suggested religious exemption language invites interpretation and argument that the legislature intends to exempt religious organizations, associations or societies or nonprofit institutions or organizations operated, supervised, or controlled by or in conjunction by a religious organization, association, or society, and extend this exemption from laws prohibiting discrimination in providing services, accommodations, advantages, facilities, goods, or privileges if the refusal to provide accommodations is related to the solemnization of a marriage or celebration.
Okay, compared to ours, compared to SB 1,
Excuse me?
it's broader exemptions?
Yes. And as far as our reading of
Do you agree with those exemptions?
well, I think that they're overly broad and they open the door to
Okay. So in it,
more than the exemption provided in Senate Bill 1, and that the religious exemption could be extended to other areas beyond the scope even of Chapter 489 because of the use of that language, notwithstanding other laws.
if we inserted some of the language from Connecticut into SB 1 and we had a testimony from the Civil Rights Commission, would you promote the passage of that bill with the language from the Connecticut law in SB 1, or would you disagree with it and suggest we do not pass it?
We wouldn't, in this process, we wouldn't agree with amendment of SB 1 in that way. But going back to Representative Bellotti's question, if the legislature passes the law, the governor signs it, and it's enacted, it's our job to enforce the law.
But is your counsel to this body or this joint committee that we should or should not exempt churches from the public accommodation law? Is it better from your perspective that they are covered by it or not covered by it? You kind of went a little bit of either side of it.
Our position is that churches' use of facilities for religious purposes and activities are exempt from our public accommodations law. There's kind of a two-part analysis there, but the thing is that we oppose legislation that incorporates exemptions to our public accommodations law. So, the thing is, a church with its facility, the threshold test that we look at is whether they offer good services, facilities, accommodations, etc., to the public. And that's only part of the test. That determines whether they fall under the public accommodations law. The second part of it is really, we look at whether they're discriminating on a prohibited basis. And so, for example, the question came up about whether refusing to have a priest perform a christening, and I may have the terminology wrong, whether that would be a violation of our public accommodations law, and the answer is clearly no, because that's a religious activity protected by free exercise, and it's not the offering of goods, services, etc. to the public. It's part of the religion, the practice of religion.
Any other questions? Representative Jordan?
Thank you very much, Chair. On page 6, the section is dealing with 572F. And basically at the end, I guess we're making a clarification that for the use of the facility of solemnization, if it's a for-profit, right?
Mm-hmm. Yes.
So who's going to deem it's for a for-profit entity? Is it going to be you? Are you going to research that? Is your division going to do that? Or who makes that decision, if they're for-profit or not?
In our testimony, our position is that the use of...
I'm sorry, could you speak up a little bit, because I really can't hear you.
Our position is, in our testimony, that the use of the for-profit criteria really doesn't fit into our public accommodations scheme at all, because it doesn't matter whether, under our public accommodations law, whether goods, services, facilities, accommodations, etc., are offered to the public for a profit or not. It's whether they're offered to the public. So the thing is that the use of
It would be really helpful if you answered the question succinctly. So is it you who make the determination or somebody else? I think that's the question. And, I just want to remind that both the testifiers and the members, we haven't even gotten to the public, and we're here to listen to the public. So if you can just answer succinctly.
I would say it could be either or both, because we make a threshold determination. Someone comes in our door, they say, I've been discriminated against. We have to determine whether we have jurisdiction. Ultimately, that determination could be reviewed by a court. So initially, the complaints, public accommodations complaint would come to us. I apologize, Chair.
So, I'm sorry, you may make a determination, but somebody might make another determination.
Well, Representative, the way the process works is that someone feels that they've been discriminated, they can come to us as a state agency and file a complaint. In our intake process, we'll make a threshold determination of whether we have jurisdiction over the complaint. So if we do, we'll accept the complaint, file it, and serve it. The thing is that we're not the final say. We're an administrative agency, so there's an investigation, there's conciliation, perhaps litigation, and ultimately the issue could be decided by the courts, and the final arbiter would be our Supreme Court.
Okay. Chair, one more question.
Okay.
In your opinion, would enactment of this measure, would this be the legislature's demonstration to say that churches and their services may be deemed public accommodations by enacting a portion of this measure, or no?
I don't think so.
You don't believe so?
No.
Okay. Thank you very much,
Okay.
Chair.
Representative Har?
Thank you, Madam Chair. Good afternoon, Mr. Hoshijo. Thank you for being here. Okay, so there's been so much controversy over public accommodations, and I find your testimony intriguing because it really does veer from that of the Attorney General's. And, we talked, and you made very clear that the litmus test for Chapter 49, over which you have purview and jurisdiction, is public accommodation, whether it's held out to the general public. Correct?
That's correct.
Okay,
That's
so
correct.
whereas in this bill, it seems for-profit is now being inserted. So can you explain, I'm just trying to understand, because the Attorney General's office really seemed to be supporting this language regarding for-profit as protecting some churches. But in your situation, your testimony really veers and you're suggesting different language.
And it does, the Attorney General is correct in that the exemption, the 572F exemption is set up to provide an exemption for religious organizations and use of facilities. And he also said that there's an exception to the exemption, that if it's for a profit, that it's not covered. And I think there is some room for different interpretations of what for a profit means, whether it means, I mean, a lot of religious organizations could argue that just by definition, we operate not for a profit. And I don't think we want to get entangled in, you know, is it because, are you making money or not? Are you just making your costs or whatever that is? And that's actually why the commission suggested that language to use the criteria or standard from the General Excise Tax Code, so that if the distinction would be between religious activity and activity whose primary purpose is producing income.
Okay, so I just, very quickly, I just want to be sure I'm clear on this then. So by basing this particular bill on the issue of profit, it could in fact, arguably, it could inject the public accommodations law because, again, depending on what your definition of profit is.
Actually, our fear is that it could create a broader exemption than even the legislature intends.
Okay, thank you very much. Thank you, Madam Chair.
Any other questions? If not, let's move on to the Hawaii State Commission on Status of Women.